I'm Stuart Dresner, Chief Executive, Privacy Laws and Business. Welcome to Privacy Laws and Business's 23rd Annual International Conference. And we have here around 200 people from 17 countries, which includes 10 data protection authorities as well. And so everyone here together, managers, lawyers, academics, and first-timers and returners, we're all part of the international privacy community. Last year we covered issues covering toxic data and questions of privacy as a business risk in the credit crunch. Those issues are still there, but we're moving on this year to question of privacy practices on trial. It's increasingly clear that your privacy practices are on trial in many ways, as I will describe later. But you do have an opportunity to put your case, although not necessarily in court, because the trial is not just a legal trial, but a trial of winning the hearts and minds of public opinion and your reputation in the media.
What I'd like to go through today is, looking at some of our keys to success, looking at some of our communication strategies, both internally and externally, how we went about gaining approval, and then finally, lessons learned from the experience, as well as what we see looking forward into BCRs. So one of our keys to success, and this is a theme that you'll see throughout the presentation, is really developing that open communication channel, both with the relevant data protection authorities as well as your outside counsel or consultant. In our case, we chose Allen & Overy in Luxembourg based upon their experience with the CMPD and existing business relationships with them. Really throughout the process, these two groups or individuals are going to be your best friends for the next year to 5 years, depending upon how complicated your business is.
Now let me mention some of the challenges, and quite frankly, the data protection landscape itself is one of the big challenges. Because what was designed to be an operation to bring clarity and harmony to national law in the 90s has now become a directive which has been implemented in 27 member states' laws, and there is substantial diversity as subsequent analyses have shown. And thus focusing on some of the member states which have been presenting here today, there is even on the national level substantial complexity. So this entire landscape in different phases is diverse and complex. That's first challenge. The second is the society in which this was adopted has changed. I don't have to make the point because you all understand, but this is getting increasingly pervasive in all areas of life. So the rules we have apply in an increasingly complex environment.
We had today the new Minister for these affairs, UK Minister Lord McNally, launching the UK government consultation on what the UK position should be in negotiations on the future of the directive. It's a 3-month consultation kicked off today. At the Information Commissioner's Office in the UK, we've been taking a strong interest in the framework, the future framework of data protection law, because it's essential that it takes account of developments in technology, it takes account of globalization, all the ways in which we use the internet. And my predecessor, Richard Thomas, will be known to many of you, back in 2008, observed that European data protection law is increasingly seen as out-of-date, bureaucratic and excessively prescriptive. We commissioned the consultancy RAND Europe to have a look at the directive and suggest a way forward that I think has influenced thinking, and that's very encouraging. And I'm very encouraged by what I hear from the current occupant of the chair of St. Peter, who is providing such excellent leadership in this process. And on that, I certainly agree with Artemi.